Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Well, let's head to Indianapolis, where they're having one hell of a heat wave. Okay, so this is going to be rare for me. Normally, I summarize, but you spent 1,000 pages on this summary, and I couldn't possibly remember it.
I have lived this case. I have lived this case with numerous firefighters, and I've done it from the managerial perspective. Okay. I've seen it. I've seen it as a firefighter among other firefighters. I've seen it as a company officer among other firefighters, and I've seen it as a chief among other firefighters. That's why I wanted to put it. So it's not my perspective. I really want to have the actual words of the court explaining the facts, but they resonate with me because I've seen this. And I really wish we were better at being able to help people like this. But at the end of the day, if you can't get to work, we can't keep you on the payroll. I think that's the end of it. But I have a lot of sympathy for him in terms of his situation. But let's get in. Now I'm getting ahead, and I'm doing exactly what I started out by saying we shouldn't do, which is we didn't explain the facts.
So we'll explain the facts. There's no way I can do this other than to go through. I tried to parse out some of your facts. It didn't cut much down. So this is going to be a very long reading for people.
Well, I'll give it to you. I'll give it to you quick if you want. Sure. And I'm going to butcher his name, but it looks like it's Sanjeev Neal, was a firefighter in Indianapolis. And he, according to the complaint, he was suffering from anxiety, depression, post-traumatic stress. Bottom line is, he also claims he was bullied and ostracized by firefighters in the academy and also by his superiors, which we know that happens. It's part of.
And maybe by the doctor. Was one of the
lines. I had maybe a different take on that. I'm not sure. Sometimes when people have certain conditions, they may misperceive what someone does. But certainly, if the doctor did what was accused, then certainly that there was. But sometimes people that are under a lot of stress misperceive something that is fairly innocent and interpret it in a way. And that doesn't mean anybody's right or wrong. It is what it is. But bottom line is, he had these clearly diagnosed conditions, and he was struggling to get to work. And he had been off. I guess he was off injured. And bottom line is, he needed help. He had been off for an extended period of time. The department, what Brad had suggested is, I provided a lengthy sort of explanation of all the things that the department had done to try to get him back to work. That's an indication that the department didn't just say, hey, you called in sick three times in a row, so we're going to get rid of you. The department did a great deal to try to assist him and get him back to be a productive member of the department. They suggested that he go away. At the end of the day, nothing that they did really seemed to help get him back to a point where he was going to be able to work, and he ended up being terminated. And he sued to try to get his job back. And the court basically said, coming to work is an essential function. If in order to be able to work, you have to be able to satisfy the essential functions of the job. And one of the essential functions is you got to be able to come to work. And if you can't come to work.
He also failed to notify them on multiple occasions when he wasn't coming. He had a number of no-shows.
Right. So it wasn't that, and you're right, it's not just, wasn't just the no-show, but it was what we call AWOL, but absent without leave. But the bottom line is, the court essentially said, and I'll try to find the quote here because I thought it was pretty good, but where is it?
And as you're looking, I'll say, I mean, there's a number of instances. In August of 2019, he failed to report to duty without notifying his superior officers. He then was suspended for 48 hours. And then on August 22nd, he doesn't show up to work, but again, without notice. So even 2 days later, he doesn't show up. So, this is one of those issues, as you're saying, where the employee is not doing his job at at the very least notifying them, I'm not going to be there. And that has real effects on employers, right? You can't schedule somebody else. You have an open shift. If you have minimum staffing, you're violating that. I mean, there's all sorts of problems that come from that. Just to throw this in, he was also didn't have his EMT certification that lapsed, and that was required. This is a hard one to stick up for the employee, despite what's going on. The employee in some sense needs to help himself. When you're done looking at the quote, I'm going to give you something that I don't think the employee thought about, but go on to.
No, go ahead. I couldn't find it, but
okay.
basically it's the court said you have to come to work. It's part of the job is to come to work. And as I think about it, I wonder if the attorney, and I'm sure the attorney made it the best argument that the attorney could in the case, but I wonder how long the attorney would have employed that person as a paralegal
Right.
if they hadn't been coming to work, to the same degree that he hadn't been coming to work.
Right. And look, we should add in, because they apparently have some sort of light duty, because he was on some sort of modified or limited duty, and he even didn't do that. So that all goes to bolster you got to show up. That, showing up is an essential job function. You can't work for a home and be a firefighter. So one of the things I just want to throw out quickly is it was interesting that they didn't appear to raise the Family Medical Leave Act, because, and I won't get too far into this for our viewers, but if you're a career department and you have not attended Curt and my FMLA, 3-4 hour in depth, the first thing that struck me is, wait a minute. If you claimed FMLA, this is an intermittent leave. He didn't necessarily have to let you know if you should have known, and maybe 48 hours early, if he's having issues, the employee or employer should have known. Now that he didn't raise family medical leave, because most attorneys aren't great at understanding it, but this could have, I'm not saying it would have, could have received extra attention under FMLA, because the employer should have been aware that he had a qualifying medical condition that may have gotten him 12 weeks of unpaid leave. I didn't calculate how much leave he used if he had it, but it certainly seems like something that should have been raised.
That issue was so in the front of my mind when I read the case that I went back and got a copy of the complaint, because I said he had to have alleged an FMLA violation, because there's a lot there. There's a lot of little nuances that maybe you didn't do this just right, so I figured at least they'd throw in an FMLA allegation. Nothing.
Yeah.
Nothing.
Yeah. And maybe that would have changed the outcome, maybe not, but it just shows great minds think alike.
Yeah, well, also as I read these cases, for the folks who are familiar with how we do things, I add them into my database, and I have categories. And one of the check boxes is FMLA and so on. So I want to get it right. I want to make sure that when I say 6.8% of the lawsuits against fire departments allege the FMLA was violated, that I have accurate information. So that means I got to go back and read the complaint, but it wasn't there.
Yeah,
no allegation.
Maybe they missed it, or maybe they made a calculated decision. We're not.
Yeah, and maybe the department did it right, and they had all their boxes checked. So
right, they may well served all the notice of rights and all that.